I'm very upset. I'm very sad today. You know what? Now I will have to give that TET exam, that is Teachers Eligibility Test. And if I don't pass this exam within 2 years, I'll be thrown from the government job. Yes, currently I work as a teacher in a minority school. Yes, there is this GR that all the teachers will have to pass this exam, that is Teachers Eligibility Test, within 2 years. And if they don't pass the exam, they will have a lot of problems in the promotion, or they might be thrown from the government job as well. So who all are exempted from this? The teachers who are going to retire within 5 years are exempted from this. Hello everybody, welcome back to another video of the series One Article Every Day from the Indian Express. And this time around I have come back with an article which talks about the Supreme Court's question to the implementation of RTE, that is right to education in the minority institutions. The Supreme Court has raised the serious questions to the past Primity judgment of 2014 that kept the minority institutions outside the RTE Act, that is Right to Education Act. The Supreme Court observed that the children studying in such institutions are deprived of getting the quality education which is their fundamental right. Let's say, for example, according to RTE, that is Right to Education, a teacher should have a desired qualifications. He should have cleared a certain examinations to be eligible as a teacher. But the minority institutions will have their own rules, will have their own qualifications. The teachers might not be having the proper degrees. The teachers might not have qualified the certain examinations. So eventually, the students will be deprived of the quality education. It might be the possibility. So this whole issue and all the previous judgments are tangled between the two articles, Article 21A and Article 30 Clause 1. Article 21A guarantees the right to free education to all the children, whereas Article 30 Clause 1 protects the right of the minorities to run their own educational institutions. So the Supreme Court says both of these articles have to be interpreted harmoniously. Both should run together and should not overrule one another. The background of this issue lies in the Primity judgment of 2014. In the Supreme Court, a bench of 5 judges was reviewing the 2 amendments. The first one is the 86th Amendment that introduced the Article 21A, and second one is the 93rd Amendment of the Constitution, which introduced the Article 15 Clause 5. The Article 15 Clause 5 allowed the government to make the necessary changes for the backward classes in the educational institutions, let that be private or the government, aided or unaided, except the minority institutions. The court upheld both the amendments, but declared that applying the RTE to the educational minority institutions is unconstitutional. And at the same time, the special character and nature of these minority institutions has to be preserved. So what do the critics of Primity judgment of 2014 argue? They say the RTE Act is child-centric and it's not institution-centric. And it's a fundamental right of every child to have the quality education. They also say that the collective rights of the minority schools to run their own institutions should not override the fundamental right of a child. So they say the RTE should be applied everywhere, in every school, including the minority schools as well.